Hi guys, welcome back to my YouTube channel. These are 16 important questions from the Unit 4 Management of Companies and Meetings. 1. Define corporate governance. Explain its importance in modern business. Definition. Corporate governance is a set of systems, principles, and processes by which a company is governed. It ensures that a company is managed in a responsible, transparent, and accountable manner. It involves balancing the interests of the company's many stakeholders, such as shareholders, management, customers, suppliers, financiers, government, and the community. Relevant sections. Section 149, Board of Directors. Section 177, Audit Committee. Section 178, Nomination and Remuneration Committee. Objectives of corporate governance. 1. Transparency. Providing accurate and clear information to stakeholders. 2. Accountability. Holding the board of directors and management responsible for their actions. 3. Fairness. Ensuring equal treatment for all shareholders and stakeholders. 4. Responsibility. Companies should follow legal frameworks and ethical standards. 2. What is an agenda? Discuss its significance in company meetings. Definition. An agenda is a formal list of items or topics to be discussed or resolved during a meeting. It is usually prepared by the company secretary or the meeting convener and sent along with the notice of the meeting. The agenda guides the flow of the meeting and ensures that all important matters are addressed in a structured and timely manner. Section 101 relates to the notice of meetings, which includes the agenda. Contents of an agenda. 1. Name of the company and meeting type, e.g., board meeting, AGM, EGM. 2. Date, time, and venue of the meeting. 3. List of business items to be discussed, e.g., approval of accounts, appointment of auditors. 4. Any special business resolutions to be passed. 5. Signature of the convener or company secretary. Types of agendas based on meetings. Annual General Meeting, AGM. Includes adoption of accounts, dividend declaration, appointment of directors, auditors, etc. Extraordinary General Meeting, EGM. Includes urgent matters like change in capital structure, alteration of MOA-AWA. Board Meetings. Includes matters like approval of budgets, business strategies, and financial policies. 3. Define the following terms: proxy, quorum, minutes, notice. Definition. A proxy is a person appointed by a shareholder to attend and vote at a meeting on their behalf if the shareholder is unable to attend. Proxy can be any person, not necessarily another shareholder. Shareholders must submit a signed proxy form before the meeting. Importance. Allows absentee shareholders to participate in decision-making. Common in large companies with scattered shareholders. B. Quorum. Definition. Quorum is the minimum number of members required to be present at a meeting for it to be legally valid and decisions made to be binding. Without quorum, the meeting is invalid and must be postponed or adjourned. Minimum quorum for general meetings. Private company, 2 members. Public company, 5 members if total members is less than or equal to 1,000. 15 members if members greater than 5,000. See Minutes. Definition. Minutes are the official written record of the proceedings and resolutions passed at a meeting. They serve as legal evidence of decisions made and discussions held. Types of minutes. Minutes of board meetings. Minutes of general meetings. D. Notice. Definition. A notice is an official written communication sent to members of a company to inform them about an upcoming meeting. It must be sent before a meeting, usually with the agenda. Contents of notice. Date, time, and venue of the meeting. Nature of the meeting, AGM, EGM, etc. Agenda or purpose of the meeting. 4. Who is the managing director? Explain his/her appointment and disqualifications. Definition of managing director. A managing director, MD, is a director who is entrusted with substantial powers of management of the company's affairs. He/she is responsible for the day-to-day operations and decision-making activities of the company, acting under the control of the Board of Directors. Section 254(196) Companies Act, 2013. Appointment of Managing Director. The appointment of a managing director is governed by certain rules and procedures. 1. By board resolution. Initially appointed by a resolution passed by the Board of Directors. 2. Approval by shareholders. The appointment must be confirmed by the shareholders in the general meeting. 3. Term of appointment. Maximum term is 5 years at a time. Can be reappointed for another term. 4. Filing with Registrar of Companies (ROC). The company must file necessary forms, e.g., Form MR1, with the ROC within 60 days of appointment. 5. Conditions for appointment. The person must be a resident of India, stay in India for at least 182 days in the previous calendar year. Disqualifications of Managing Director. A person cannot be appointed as MD if 1. Age restriction. Less than 21 years. More than 70 years, unless approved by special resolution. 2. Unsound mind. Declared mentally unfit by a court. 3. Insolvency. Undischarged insolvent or has applied to be adjudicated as insolvent. 4. Criminal conviction. Convicted and sentenced to imprisonment for 6 months or more for moral turpitude. 5. Suspension by law. Barred by any law or regulatory body from holding office. 5Q Duties and Liabilities of Directors, Companies Act, 2013. Duties of Directors. 1. Act in good faith, work honestly and in the best interest of the company, employees, and shareholders. 2. Avoid conflict of interest. Directors must not make secret profits or take advantage of their position. 3. Use reasonable care and skill. Must act responsibly and stay updated about company matters. 4. Follow the law. Directors must comply with the Companies Act, company rules, and guidelines. 5. No undue gain. If a director gains unfair benefit, they must redeem it to the company. Liabilities of directors. Civil liability. If directors are careless or negligent and cause loss, they must compensate. Criminal liability. Fraud, cheating, or violating legal provisions can lead to fines or jail. Statutory liability arises if they fail to meet legal requirements like filing returns or maintaining records. Q6. Appointment and removal of directors. Appointment of directors. 1. First directors, named in the Articles of Association. 2. By shareholders appointed through voting in annual general meeting. 3. By Board of Directors can appoint additional, alternate, or nominee directors. 4. By institutions, banks or financial bodies can appoint nominee directors. 5. By government in case of oppression, fraud, or mismanagement. Removal of directors. A director can be removed by passing an ordinary resolution in a general meeting. The director must be given a fair chance to explain before removal. The company must inform the Registrar of Companies using the proper forms. Q7. Corporate Social Responsibility, CSR. Meaning, CSR is the company's duty to contribute positively to society and the environment while doing business. Applicability. CSR is mandatory for companies having net worth of 2,500 crore or more, or turnover of 21,000 crore or more, or net profit of 15 crore or more. CSR activities, as per Schedule 7. 1. Eradicating hunger and poverty. 2. Promoting education and healthcare. 3. Women empowerment and gender equality. 4. Environmental sustainability. 5. Rural development projects. 6. Support to PM relief funds and disaster recovery. Q8. Liabilities of directors. 1. Statutory liability when directors break laws such as not holding meetings or filing documents late. 2. Civil liability if the company suffers loss due to their careless actions. 3. Criminal liability. Fraud, misstatements, or cheating can lead to jail or fines. 4. Contractual liability. If directors personally guarantee a loan or agreement, they are liable. 5. Fiduciary liability as company trustees. Directors must protect company assets and act fairly. Ill directors don't perform their duties properly, they may face legal action, be fined, or removed from office. Q9. Types of shareholders meetings. 1. Annual General Meeting, AGM. Held once a year. Discusses accounts, appoints auditors, and approves dividends. Compulsory for all public companies. 2. Extraordinary General Meeting, EGM. Called for urgent issues between AGMs. Discusses matters like removal of directors, alteration of capital, etc. 3. Class meetings. Held for shareholders of a specific class of shares, e.g., preference shareholders. Used to make changes in their rights or privileges. Each meeting serves a different purpose and is essential for transparent company down-pointing arrow. Operations. Q10. Extraordinary General Meeting, EGM. Meaning. An EGM is any general meeting of shareholders held between two AGMs to deal with urgent business matters. Who can call EGM? Board of Directors. Shareholders with 10% or more voting rights. Tribunal in certain legal cases. Objectives of EGM. Remove or appoint directors. Alter share capital or change company structure. Approve urgent financial decisions or agreements. Merge or restructure the business. EGMs are important for making quick decisions that cannot wait until the next AGM. Q11. Duties of directors. 1. Act with honesty and integrity. Directors must work sincerely for the company's benefit. 2. Use reasonable skill and care. They should stay informed and make careful decisions. 3. Avoid personal profits. Directors must not use company information for personal gain. 4. Attend board meetings. They must actively participate in company decisions. 5. Follow the law and rules. Must respect legal obligations and company policies. If a director fails to do these duties, they can be removed or penalized under company law. Q12. Notice of company meeting. Definition. A formal notice sent to members, directors, shareholders, to inform them about a meeting. Content of notice. Date, time, and place of the meeting. Agenda, topics to be discussed. Signed by company secretary or director. Rules for valid notice. Sent at least 21 clear days before the meeting. Can be delivered by hand, post, or email. Must be sent to all eligible members. If notice is not sent properly, the meeting is considered invalid and decisions may be challenged.